couldn't identify him, so it's therefore not reckless on the part of Tom Lewis. I understand that, but what other officers in different agencies on different dates before this could and couldn't identify isn't relevant to what Officer Cole could or could not that day.
It was the same firearm and the same box of wad cutters, correct?
And it's not, that's factually, I think it's disputable. Nobody can really tell what ammunition was being used.
Okay.
The Florida Department of Law Enforcement went out, searched for hours and hours, pulling projectiles out of, I believe it was at the gun range in Charlotte County Sheriff's Office gun range, out of a berm where they thought maybe this was being fired by Officer Cole, and they weren't able to match any sort of projectile or determine anything about what was actually being used by Officer Cole. So there's a lot of questioning, and nobody really knows if we're talking about wad cutters or Winchester blanks or some other type of blank. Nobody really has any idea, and it can't be stated that we know for sure what was being used.
I would respectfully disagree. First of all, we know, at least from Lee Cole and the representation of his lawyers, that he fired off 10 rounds there. He's already told the state that, so they have that information. So to say that there's no evidence of that to begin with, they already have that. We have that in a letter from his first lawyer. But secondly, the person that's out there with him that sees these wad cutters is his training officer who's familiar with wad cutters and will testify because they are so archaic, we don't even think they're here. I looked at them, they're blanks. So they're blanks, and then you recognize they're not the Winchester blanks that they use, which is really all that's completely relevant to this because the only thing the Florida Police Department gives him are the Winchesters. And he's like, that's not what I was looking at. They were something new, and I asked him, what, did you get new blanks? And Lee Cole responded, yeah, they're a lot cheaper to buy, or something along those lines, which is also relevant to this.
Well, I can't say that this is not relevant. So the question is it unduly prejudicial to the state? And I don't believe it is. So I think it's absolutely relevant to their theory of the case. Now, obviously, if there's a factual dispute as to what exactly happened, that's something that's going to have to come out during the testimony. But as it's laid out here, I'm going to deny the motion in limine. And obviously, like I said, if there's a factual dispute as to it, then that will be addressed during the testimony. Number 4, state's motion objecting to admission of documents in defendant's notice of intent to rely on business record. All right, number 1 has, from what I could tell, are they multiple different documents or is it one group?
Yes, Your Honor. The defendant's notice listed the 2015 accreditation assessment report. Basically, this was done by an outside group that came in and evaluated the police department in 2015. And then there are 3 different dates for the K-9 train records, 4 different dates. The state's position is that all of those listed documents are irrelevant with respect to the K-9 training records on all 4 of those dates. They have no relevance to the facts of our case. With respect to the accreditation reports, I attached it as an exhibit. If the court would like, I have another copy as well.
I have it.
I might be able to put the chase in the accreditation
All right.
report. I don't necessarily, the accreditation report was for the purposes of that it is a business record that they do have in there. It's an issue that goes to state of mind. One of the things they've raised is that there was something about insufficient policies. But the policies are reviewed by the accreditation agency. So as far as my client's concerned, as the state of mind as to why he would not believe or think that something's wrong with the policies, when you've had the policies reviewed and accredited every time, like no one says you're missing something here. It's really a state of mind thing as to whether he acted thinking, I'm going to hurt somebody, or acted thinking, well, our policies appear to be okay because we've gone through this. So I don't necessarily even need to enter the document, but in fair notice to the state, I listed it because it is done in their course of their business practices. And if that resolves it, if it's just the document itself they don't want entered, obviously I can enter anything that's relevant to his state of mind as to why he would believe certain policies were or were not needed.
Or you can simply ask, were they accredited by whoever did the accreditation?
Right, and in the process of their review policies, yes, they might alert you that you're missing a policy about, public demonstrations or something of that nature.
Okay. Well, I agree with their motion, that the accreditation of FDLE, and FDLE is the one who made the document, produced the document, even though they hold it in their file, does not make it a business record per the statute. So I'm going to agree for the purposes of submitting the document under business record, notice of intent to rely on business record certification. After that, I don't know where you go. I mean, obviously, I think it is relevant that they've been accredited depending on what happens, but I don't think you can use the business record certification to get it
That's
in.
fine, just so anybody said that it wasn't something we were referring to that wasn't there to come on notice of. But it's really, he can testify to it as to what he already knows.
So I'm going to grant 2015 accreditation assessment report, motion in limine. Then we have the training records. And my understanding of the training records are, these were the records of the events where they did a similar type event. Is that correct?
Correct, they're canine training or other demonstrations, I believe, yes. Not citizens academies per se or chamber police night, but officers firing firearms, yes. And Judge, I filed the notice of objection just to preserve, so we don't waive it by failing to file a response. If the court wants to reserve ruling until you hear evidence, that's certainly fine with the state.
I think on those I have to, because I don't think right now there's enough information for me to say whether they're relevant or not. So,
I mean, they're listed, those are all dates before he was chief, and then obviously go to state of mind, and go to the state is listed in as one of the facts within the information that which supports the charge by itself, is that the use of a gun that fires blank in and of itself at a community presentation is a crime. And again, he's countering the fact that it's well known that that's done, and it's not alerting somebody that it is a crime. And these are all the same things before he's even in authority as a chief.
well, my findings on that is, you're not objecting to the actual business record. You're not saying these aren't business records, correct? You're just saying that these are not relevant.
Correct.
Okay, so I do find that they would in fact be business records under the certification. I'm going to reserve on the relevancy depending on how the testimony comes out. And motion in limine and objection to admission of armory records in state's notice of intent to rely on business record certification. Armory record of 2017.
Those are all post-event, and they actually are records that would reflect what was kept in there after they made certain changes after this, which of course already ruled that out, so this is kind of an extension of that.
Jared, I don't know what remedial measures defense counsel's talking about that the 2017 record shows. One of the main things is you'll hear from multiple witnesses that they had no idea what training weapons were in the armory, and now miraculously the 2016 records are gone. So we've got 2015 and 2017, and we get to bring that up to the jury. I don't think the 2017 record in and of itself alludes to anything about remedial measures, if Your Honor would like to see it.
But why does it need to, why does it need to go into evidence? If the motion in limine has been subsequent remedial measures, which you've agreed to, aren't coming in, how then is the 2017 armory record relevant?
That's fine. It shows the same miscellaneous items, which include the training weapons. As long as we can elicit testimony about it, that's fine.
Okay, so I'll grant armory record 2017. Obviously, you can elicit testimony about things, but you, per our previous ruling and motion in limine, you can't elicit testimony that it's changed from the date of the event to 17.
And that's fine, Your Honor. I'm not
Okay.
necessarily wanting to talk about what's in it, but I want to know what's not.
Well, I don't think they could refer to anything testimony or document of anything after August 9th. That's the whole point. None of that's relevant what happened in the Armory afterwards.
I think they can testify, if they're supposedly missing records, I think that they can elicit testimony that the 2016 is missing. There is in fact a 2017, but I agree they can't get into what is in the 2017. Is that the state's understanding as well?
Yes, Your Honor.
Okay. So I'm going to grant the admission of the armory records are not coming in. Testimony of what is in them is not coming in, but I do find that if there are missing records, they can get into, that there are armory records now, there were in 15, and there somehow weren't in 16. I don't know.
Yeah, and I'm just for the record, I don't necessarily agree with that, because that they're missing, so if they set a predicate for it, or somehow it's the testimony that it is, I don't think that even can be the case because of what you have to do to be accredited, but if they couldn't find it on what they did, it doesn't mean the record is not out there.
That's
Okay.
way beyond what I know right now. And then the same with 2015, is it the same, the purpose of using the 2015 was to show that there is a 2015, couldn't find a 16, and then there is a 17?
I think the contents of what was in 2015 is relevant.
Was it changed in 16 during this event?
I don't know. I requested the records and I don't know.
No, that's the same thing. Yeah, that's right.
Okay, then, tell me then how the armory records from a year prior to the event are relevant.
The state anticipates that the defense is going to make a claim as to what Tom Lewis knew or didn't know regarding a training revolver that the department owned. When you ask the witnesses, or at least when the state asked the witnesses, we've gotten at least 10 different answers as to what it was. The 15 records are the closest thing we have to an accurate
I think show it was before the event was even planned, which was earlier in the year also, so.
I'm going to reserve on that. I think number one goes directly to potentially subsequent remedial events. I think number two potentially could be relevant. So I'm going to reserve depending on how the testimony comes out.
Just for clarification, on that, when that comes up, is that something when it comes up that we're going to take care of it with the court of defense first or something before we go into it? Like, I don't want witnesses blurting something out because of this, if we haven't made a rule.
Well, the record's either going to come in or not, so I don't know what the witness would blurt out.
Or if they reference it. Well, in our 2015 record, it said, of course, I'd object, but are we going to take care of that then?
We'll see how it goes. We'll see how it goes. Is there anything else that we need to take care of?
The only other action we had was the one we did not address last week, which was the motion to verify about the law as to.
Okay. Well, basically, my ruling is this. Azima is a binding Second District Court of Appeals case at this point. I'm not making a determination right now with regard to any particular jury instructions. Again, we haven't received any testimony or evidence, but the court is bound to follow the law of Azima at this point.
Thank you.
Okay. How long does everybody anticipate for openings?
Your Honor, if we could just go back to the motion briefly, what is that changing then?
I don't know.
Okay.
He asked me to clarify what I thought about the law, and my understanding is Azima is good law. So that's
Thank you.
you're welcome. How long does everybody anticipate for openings?
15 minutes.
All right, and does anybody need a quick recess before we bring the jury out? I know you were doing Does anybody anticipate using this smart board for opening? Do we need to finish that?
Not for opening, John.
Anybody need a recess before openings, or?
I believe we're ready now.
I'll instruct. Okay. The notepads for note-taking are already on there, so I will just read the instruction on note-taking. I would prefer them to just have them, given the length of the trial, versus waiting for them to ask. Is there any objection?
No objection.
Okay.
Before you, the acceptance, we do that at the bench, because I have to note certain things that I would have sent to the bench.
I'm sorry, what?
Before we do the acceptance of the jury, because I have to note certain things, obviously, we do it outside the presence of the jury. When you ask if it's accepted, I have to say acceptance subject to any objection that we made.
Oh, I gotcha.